Okay, folks, welcome back to our series of lectures on real property, bankruptcy, and antitrust. In this next couple of lectures, we're going to talk about antitrust. I hope you were able to read the introduction to the chapter on antitrust because it told you why the word antitrust means something. It was set up in the late 1800s because the corporate barons of the time would get many different companies and put the shares of stock in those companies in a trust, and the trustee would be able to tell the various different kinds of the various different companies how to run their company because they owned the stock, and so it was all in a trust, and so that's why they passed the antitrust laws. Okay, now antitrust are both U.S. and California. The California antitrust law is called the Cartwright Act. Did I spell that right? Yeah, it looks like it. Okay, the antitrust law in California is called the Cartwright Act. The U.S. antitrust law is called Sherman Act, the Clayton Act, Robinson-Patman Act, whoops, the Federal Trade Commission Act, that's an F, Federal Trade Commission Act, and several different other acts. We're going to mainly talk about the Sherman Act today. Now, the California Cartwright Act, in essence, takes up all of these other federal acts. So if it's a violation of a federal act, it's probably a violation of the California Cartwright Act. Okay, the Sherman Act, first thing I want to tell you is these acts have both civil penalties and criminal penalties. You can have lots of civil penalties about these things, and you can also go to jail and pay big fines. For example, one of our current events from last week was about a Florida cancer center that just pleaded guilty to a Department of Justice criminal investigation for fixing and allocating customers in Florida. They agreed to pay $100 million fine. Okay? And for sure, there are going to be some civil cases that come along with that. Why are civil cases so good in antitrust? Because in the civil actions, you get 3 times the damages that you can prove, plus attorney's fees. So if you can prove, let's say you can prove $30 million worth of damages because of the antitrust violation. 3 times that is $90 million, plus you get your attorney's fees. And normally the attorneys take these things on a contingency. We talked about contingency fees. So they get not only the attorney's fees, but they get part of this as well. So attorneys are very, very eager to get civil antitrust cases. So just remember, there are both civil penalties and criminal penalties for antitrust violations. There's some exceptions to antitrust violations. For example, companies can get together and do and lobby the government. That's called a governmental exception. But the weirdest exception is baseball. Since there's been a Supreme Court in the early 1900s that said baseball is not an interstate business, and therefore it is not a violation of the U.S. antitrust laws. It's totally weird because all of us know that baseball is in fact an interstate business, okay? The U.S. Sherman Act in Section 1 says any combination, contract combination, or conspiracy in restraint of trade is illegal. So if you have a contract combination or conspiracy to restrain trade, that's illegal. Section 2 says that monopolization is illegal. Either monopolization or an attempt to monopolize. You can have either one of those two in the Sherman Act and violate, there will be violations of the Sherman Act because either restraint of trade or monopolization. Now there's two kinds of antitrust laws, two kinds of violations of the Sherman Act. For example, there's a horizontal violation where Company A agrees with Company B and Company C, and these guys get all the customers in the West, these guys get all the customers in the Midwest, and these guys get all the customers in the East. You see why it's called a horizontal? Because it is companies all on the same level, and they're allocating customers, or they're allocating territories, or they're agreeing to fixed prices or something like this. These guys are all on the same level. That's why it's called horizontal. And if you do that and they can prove it, you're guilty. You're guilty, okay? If you can prove a horizontal violation, you're guilty. The other kind of antitrust violation is a vertical violation. And it's vertical because Company A agrees with somebody in its downline, Company B, who agrees with somebody in its downline, Company C. Okay? That's vertical. You see? It's going up and down. The big thing in this area is price maintenance, where Company A says, I'm going to sell it to Company B, but you've got to say it's only going to be 2 times the dollars, and I won't sell it to you unless you agree to that. And Company B says, I'm going to sell it to Company C, but only 3 times the dollars. You can sell the product at this price, and this price, and they've all agreed. You see how that's a vertical agreement? This is, you've got to prove not only that they did it, but you've got to prove that there was an adverse impact on competition. You've got to prove, did it, plus an adverse impact on competition. And if you can't prove the second part, then you don't get an antitrust violation. Now folks, don't be talking prices, don't be talking allocating customers, don't be talking allocating territories with your competitors, because then you're going to be in a horizontal violation, and if they can prove it, you're going to be found guilty. And the local district attorneys and the local U.S. prosecutors are always looking for these kinds of things. Not too many years ago, just a couple of years ago, they found a couple of property buyers who were buying properties at foreclosures. There was 3 or 4 of them, and they agreed that Person A would bid on the first property, person B would bid on the second property, person C would bid on the third property. Therefore, there was less competition in the bidding. They were found guilty and they were charged